Good morning, everybody. Thank you all for joining us. We are going to give folks a couple minutes to get the rest of us in from the waiting room, and there we are. I think that's all of us. All right. Thank you so much for joining us today. Excuse me. I'm going to start like I usually do with our Zoom housekeeping tips this week, which begin with reminding you to please stay muted unless you would like to unmute yourself to ask a question, which you're welcome to do. But otherwise, if you could stay on mute, that would be helpful. It just helps cut down on background noise, makes for a better recording. Your audio and video buttons, audio being the one that you will use to mute or unmute, are at the bottom of your screen, probably, depending on the kind of device that you're using, along with all of your other Zoom toolbar items, which would include the chat button. That might actually be flashing, again, depending on what kind of device you're using, because I just put a message into the chat. The chat is the best place to put questions or requests for clarification today. If you have questions that you'd like to ask us, we might have time to get to a couple from the chat. The message that I put into the chat also tells you the best way to submit questions for future Q&As, and also gives you the link to our YouTube channel where you can see the recordings for all of our, I think, 2 years worth of Q&A videos are up on that link in our YouTube channel. Excuse me. Another thing that we share with you every week is just a reminder that we are here to give general information, not to give legal advice. And so sometimes what that looks like is Chelsea will email you back saying that a question you've submitted is too specific and we can't cover it in this forum. Please don't get mad at Chelsea. She's not the one who makes those judgment calls. It's us, usually me. So if you want to be mad, you can be mad at me. Also keep in mind when you're formulating your questions that if you find yourself having to give us excerpts from your governing documents or, several paragraphs worth of detail before you actually get to the question that you're asking, it's probably too specific. So when that happens, we do try when we can to cover the subject matter in a more general way. We aren't always able to do that. And so sometimes things are just too specific for this forum. Again, we're here to give general legal information, not give legal advice. We have a couple of events coming up that we wanted to remind you about. May 16th, which is actually this weekend, is the WSCAI pickleball fundraiser for the LAC. I'm going to copy and paste the link to the WSCAI event in the chat. Two of our attorneys are going to be there. In fact, I think they're both on this Zoom call today. So Diana and Fatima will both be at the pickleball tournament. Are you guys playing or are you spectating?
Yes,
We're
playing.
playing.
All right. So if you would like to go watch the athletic prowess of our lawyers,
Or
you
just come
go
laugh at us. That's fine.
and keep in mind that you don't have to play. So if you don't have plans on this Saturday, the link is in the chat. You do not have to play in order to attend the event. And it is a fundraiser for the Legislative Action Committee. And we would really love your support. So please consider going to that. I think it's going to be a really good time. Another event that we want to remind everybody about, which is also related to the LAC, is the virtual law day that is coming up on June 9th. I put the link for that into the chat as well. Two of our attorneys are going to be speaking at that event. There is going to be a ton of information about legislative changes and updates. Our lobbyist is going to be there to talk about this past legislative session. We'll talk a little bit about some of our priorities for the upcoming legislative session, as well as lots of content about WUCIOA. So that again is on June 9th, and the link for that event is in the chat. We hope that you will join us then. And one other date-related announcement is just that we are not going to do the Q&A the week of May 27th being the Wednesday. That happens to be the week of Memorial Day. We typically take holiday weeks off from doing the Q&A. So mark that in your calendar. That's a couple weeks from now. We won't be doing the Q&A that week. I think that covers all of our announcements. So unless somebody else has something else to add to that list, then we can just go ahead and jump into the questions.
Okay, I will kick it off with question number 1. How far back should files be kept? We have no storage. So the files are in my garage. I wonder about insurance for myself and the HOA. Can folks ask for files way back? That would, of course, take oodles of time finding, meeting somewhere with them to let them review. Can we charge for that? So there's a bunch of questions in here. I'm just going to kind of go through one by one, answering the question, and hopefully I'll be able to answer it in the way that it's been asked. To start, RCW 6490 lists section 495.1 lists exactly which types of records and how long they must be kept. So if you're just looking for, it's literally a list. So you can just look at that statute and see, okay, what are the things that I have to keep? Other statutes have similar language, so I'm just using that one as an example. All you need to do is Google the statute that your association is formed under for now, and it will tell you exactly which records are required to be kept. There is no requirement that hard copies, paper copies, need to be maintained. In fact, many associations have digitized their records and shredded the hard copies, so that's fine. The records must be maintained. The rule is that they must be maintained so that they are retrievable. So that's sort of the standard. You can check regarding insurance, you can check your property insurance policy to see if there's some type of coverage. But regardless, even if you have coverage under your policy for a loss of records does not it does not excuse your statutory requirement to maintain them to begin with. So that's not necessarily going to help you in the event that you haven't followed, if you haven't maintained the records according to the statutory requirements. Owners can ask for records, anything that they want to see. The obligation is on the association to determine if the record exists and to produce it if it's been asked for. Again, RCW 6490-495, Section 5 states that an association may charge a reasonable fee to produce and provide copies of records, as well as supervision for inspection, if and when that's required. Let's see, a couple other details here, nuances. Even if you're not required to keep a document, so even if it's not listed as one of the required documents, but you have it anyway, our position is that you still should allow an owner to review it if it's something that you have, even if it's not required. We also generally recommend an annual purge of records for anything that is dated later than what is required to be kept. And keep in mind that this statute went into effect in 2023. So as an association are not responsible for missing records prior to that date. And again, we do recommend that you do an annual review, review of your records and get rid of anything that is unnecessary, not required. Hopefully that answers all the questions that were asked. Val or Diana, do you have any thoughts on that question?
Nope, I have nothing to add. Excuse me. I'm going to take us to our next question. When short-term leases are not allowed, but a homeowner leases their unit as an Airbnb for long-term leases for 6 months, can the governing documents section, sorry, the question is phrased kind of funny. Can the governing documents section regarding single-family use be applied? It's like the owner is using a crafty way to meet the rental term guideline. And I think the answer to this question is no. Rentals to single families are the same under Washington law as owner occupancy when it comes to whether something is defined as single family use. And if your documents prohibit leases shorter than a certain length, 6 months or a year, and the owner is not violating the lease term restrictions in your documents, then it doesn't matter what platform they're using to list their unit for leases that are consistent with your minimum lease term. In other words, I don't know if you guys know this, maybe I'm showing my age, but it used to be that when I was looking like for an apartment to rent or something, you'd go to apartments.com and these websites that would aggregate rentals like that. But you could also go to like the local Windermere office website, and they might have a few apartments or single family homes for rent that they were managing as a listing, right? Going to Airbnb and renting an apartment or a condo for 6 months is no different than going to one of those types of websites and renting it for 6 months. The important thing when it comes to your rental restriction is whether the owner is complying with the minimum lease term, not what website they're using to list their property for rent. So, unless I'm misunderstanding something about the question, I don't think using Airbnb to advertise a lease that is consistent with the minimum required in the CC&Rs is a violation. I also think one thing that it's important to keep in mind is a lot of people think that short-term rentals equal commercial use, and that is not the case. Washington courts have looked at this question and have determined that because the way short-term tenants use a property is the same way, the same type of use, meaning, they sleep in the beds and they cook in the kitchen and they park in the garage. The type of use dictates whether something is considered single family use versus commercial use, not the length of the lease. So that's an aside to the primary question, which is essentially, does listing your unit on Airbnb violate the the rental restriction, even if the lease term is 6 months or more? And I think the short answer to that question is no. The platform or the website or the app that they use to list it is not the controlling factor. The controlling factor is, are they leasing the unit for more or less than the minimum lease term that's defined in your governing documents? So I think that answers the question. I think anything probably more specific than this gets to, venturing into the realm of legal advice. And if you've got this situation in one of your communities and you think that my answer is wrong or that I've misunderstood the question or anything like that, feel free to reach out to your association attorney to submit more specific questions on that. Any other comments from Diana or Tima?
Nope.
I don't think so.
I
Okay,
can do.
I'm just gonna take a minute to introduce everybody to Diana, not to make you even more nervous than you might already be. Sorry, Diana, but
No, that's
some
okay.
of you that come every week might recognize Diana. Some of our general legal clients might also recognize at least her name, having been emailing or on the phone with her. Diana is one of our newer associates. She's been with the firm for about a year, and we are excited to have her starting to join us for the Q&A. So take it away, Diana.
Okay, well, I'll do the next question, question number 3, and it says, what do boards typically require of an owner that is asking to have a heat pump installed? Are flashing details often asked for? And the answer to your question largely depends on the kind of property you're in. So a stacked condominium would have different needs than a townhome or single family home. You can adopt a heat pump policy though, and include a provision requiring flashing details. And of course, this policy should not conflict with the governing documents, just like all other policies in your community. And the statute that's applicable to this question is RCW 649580, which is the statute for heat pumps, and it applies to all associations today. And that statute has a list of what the association can and cannot do regarding heat pumps. So I suggest taking a look at that. And a few things the board should keep in mind would be the sound levels produced by the heat pump unit are important. Where the outside unit will be placed is also important. Will it be on the roof? Will it be on the deck? And if the building envelope is the association's responsibility, then details on how the penetrations are made may also be important. And lastly, requiring permits and work to be done by a licensed and bonded contractors is typical. And yeah, anything else to add, Valerie or Tima?
I don't think
I
so.
don't
I think
think
we covered it.
Okay.
Thanks, Diana.
All right, the next question that we got is a long one, and it's a multi-part question, and it starts this way. I am the president of my association in Walla Walla, and I just need confirmation or clarification that I am understanding WUCIOA and Senate Bill 5796 correctly. Could someone please confirm or clarify my understanding? And the question goes on to say that they assume that starting on January 1st, 2028, WUCIOA will be the rules and regs for all HOAs, regardless of age, pre-2023 HOAs are exempt as a private contract until January 1 of 2028. So you're partly correct here. Some parts of WUCIOA apply to all associations in Washington state today already. So if you want to look at RCW 6490-365, that gives you the list of the sections of WUCIOA that are applicable to all communities in Washington state as of today. That includes the budget ratification section. It includes the heat pump section. It includes the meetings section. And that's the newest edition as of January 1, 2026, right? I want to also clarify that WUCIOA has been in existence and has been the governing statute for all new community associations created on or after July 1st, 2018, not 2023. So if you're a single family home HOA or a condo association for that matter, or a townhouse community, and your declaration was recorded on or after July 1st, 2018, then you are a community that is subject to WUCIOA. You can look at our previous YouTube videos for a lot more detail about the laws that went into effect on January 1 of 2026. And as to your question about January 1 of 2028, you are correct. WUCIOA will be the only remaining common interest ownership statute in Washington state as of January 1 of 2028. The question goes on to say that Senate Bill 5796 states no common interest communities will be allowed to have restrictions that violate state or federal law and will allow a board to amend the CC&Rs without a member vote, since members cannot vote on whether to obey state or federal law. So I think you might be misunderstanding that section a little bit. I want to start by saying that no common interest community now is allowed to have restrictions that violate state or federal law, period. That is true already for all communities. And the amendment section that you're referring to in WUCIOA that allows the board to amend without a vote of the ownership is only to remove language that directly conflicts with WUCIOA, with the statute. It does not allow you to replace that language with anything else. It doesn't allow you to do any other sort of material amendment to your governing documents without a vote of the ownership. The only thing that the board can do on its own without a vote of the ownership, and again, this is not until January 1 of 2028, is adopt an amendment that strikes portions of the declaration that directly conflict with the statute. So you will need to have an amendment that is voted on by your ownership if you want to change anything, if you want to replace any of that conflicting language with something that doesn't conflict with the statute, if you want to adopt any new types of restrictions that don't exist in your documents, all of those types of things will require a vote of your ownership. And the last part of the question is about ADUs, which talks about how HOAs will no longer be allowed to prohibit ADUs in their community and will have to amend their covenants. So I want to say this. The statute will prohibit new restrictions on ADUs, but that does not mean that existing restrictions will not be enforceable. But there are rules about that, and including you have to be enforcing them now rather than waiting and then only enforcing them later. You want to be really careful about the potential for like a selective enforcement claim. And the short version is that you need an attorney to review this question. And the other thing to keep in mind is that there are county and city or like local municipality rules around ADUs as well. So this is not a simple thing where we can sort of read you two lines from the bill or the statute and you have a complete and full understanding of what the rules are for ADUs within your particular community. There's additional moving parts here. There is a difference between the language single family use and the language that says one single family dwelling per lot. So that's language that is different and might result in different outcomes when it comes to whether or not you can limit ADUs within your community. And boards always have discretion when it comes to the enforcement of covenants. And that is something under WUCIOA that you look at 6490, 405, subsections 7, 8, and 9. Again, that's 6490, 405, subsections 7 through 9. But the real answer to this particular question with respect to ADUs is that we can't give you guidance on this in this forum. You need an association attorney to review the statutory changes as well as your existing governing documents, who also has an understanding of any local ordinances that might impact your ability to prohibit or the requirement that you have to allow ADUs. And if you don't have an association attorney, you should work on getting one now, right? It's only May of 2026. You've got not quite 2 years until WUCIOA for All takes effect, which gives you a good long time to establish a relationship with an attorney that understands community association law and your particular community in specifically, and who can advise you on what you need to be doing in this sort of lead up to January 1, 2028. I would not recommend that you wait until 2 or 3 months before that date to start the search for your attorney, because there are things that you can and should potentially consider doing now that will impact how things play out for your community in 2028. So if that's not a relationship that you already have, then I would recommend you go to the WSCAI website and look at the member directories. There are, lists there of member management companies and association attorneys and accountants and all kinds of different professionals who, like, this is what we do. We serve community associations. And the one other caution I'll offer is don't I know there, especially in smaller towns. I grew up in one. I grew up in the San Juan Islands. I know there's a limited number of attorneys locally, and there's a temptation, I think, to use, your neighborhood attorney for a lot of things. They are generalists. They often do a lot of different stuff. I would caution you against using someone who does not specialize in community association law. Our statutes are very, very specific. This is a really interesting niche practice area, and somebody who is, for example, an amazing real estate attorney might have very little understanding of how the common interest statutes impact your association. So I would strongly recommend that you try to go with somebody who's a specialist in this particular practice area versus somebody who's really good at real estate, or somebody who's a fantastic attorney in your local community but doesn't have community association law experience. So I'll get off my soapbox now. I think that answers most of the question. If you guys have comments to add, please feel free.
I think that answers the question. I'm going to move on to question number 5. If the board wishes to meet to discuss replacing the community association manager, does the meeting need to be noticed and use the same procedure for going into closed session when you adjourn the meeting and then closed session when you adjourn the meeting, go to closed session, and then come out before you adjourn the meeting? This would be problematic as the association manager notices the meeting, so they would know that we were meeting to discuss replacing them. Also, when we are interviewing possible management companies, does this also have to be noticed? The bottom line is yes, notice is required. The statute effective January 1, 2026 makes it very clear that all meetings must be open, and they all require a minimum of 14 days advance notice given to the ownership. So it doesn't matter what the meeting is about. You always have to just remember open meeting, notice is required. Now, with regard to the specific question, I would say our answer is going to be that you, as the board, you may send the notice directly to the ownership as opposed to having the manager do it. The manager doesn't have to be involved. The manager is an agent of the association. However, if you wanted to notice a meeting that did not include the manager, you could certainly do that on your own without involving them. And again, the manager doesn't need to be included or attend the meeting. So if you're meeting to discuss replacing a manager, certainly that would be my recommendation. Now, the discussion about replacing the manager does not fit into any of the exceptions for the open meetings, which seems to be what you're referring to in the question when you mention going into closed session and then adjourning and then returning to open session to adjourn the meeting. It seems to me that that's what you're suggesting here, is that you would want to discuss this topic in executive session. So our recommendation, like I said, would be you don't have to include the manager, but the meeting does need to be an open meeting. And so the discussion around replacing a manager does not fit into any of the exceptions that are listed as the permissible reasons for holding an executive session. So if you're considering making a change, you're going to want to think about just not, in other words, if you're the executive session is not the time to be discussing that. It's to be discussed in open meeting, and you certainly can't make any decision about replacing a manager except in open session. Now, if you are considering making a change of management, you could allow your current manager to apply to renew their contract while you evaluate the alternatives. You could also recommend a request for proposals so that all managers would know that you're expecting certain that you're setting certain expectations of them moving forward to establish a new procedure. And then as far as interviewing management companies, that could technically be conducted outside of an open meeting, but we wouldn't really recommend doing it. It's why, it's certainly relevant to the entire ownership. And so there's no reason why we don't really see a reason why you wouldn't want to have that at least be offered in an open meeting. And clearly, just as the decision to replace a manager, the decision to replace a management company must be made in an open meeting. Trying to think. I think that covers the question as it was asked, at least the way we understood it to be asked. Valerie or Diana, did you want to add anything to that?
I would love to add something, which is that we've got a bunch of managers on this Q&A right now, and just like law firms see clients come and go, management companies see clients come and go all the time. It's kind of part of doing business, especially the longer that you're in business within a particular industry. And I know that it probably from the board's perspective feels like a really kind of big, like, oh man, there's going to be drama. The manager's going to be mad at us or whatever. And that is almost never how these things play out. So I think the temptation to want to have these conversations behind closed doors probably comes because of an anticipation that once the manager finds out that we're looking for a new company, they're just going to ditch us. They're going to stop serving us. They're going to be a jerk to us. They're going to create drama. And that is really, truly, very rarely how it actually plays out in the real world. Managers are professionals. They see clients come and go and come back again sometimes, depending on how long you're in the industry. And I think they for the most part, handle it just like all of the law firms in our practice area do, which is that clients sometimes switch around and they might go to another law firm and then 10 years later, they might come back, and it's the client's decision who they want to work with. And nobody is out here, or very few people in these professions are out here looking to force clients to stay with them and to turn it into something akin to like a romantic breakup with drama when a board decides to move in another direction. So give your manager the benefit of the doubt, and don't assume that bad things are going to happen when they find out that you're considering a change in management. If you don't have a reason not to, when you send out the RFP to potential management companies, you can certainly allow your current management company to submit a proposal in response to that. And you can consider, one other thing that I think is worth mentioning that we always tell our clients when they come to us saying that they want to change management companies is consider whether changing from one individual manager to another one within the same company might accomplish the same end result that you're looking for. Sometimes the relationship between an individual manager and a particular board just goes sour for whatever reason, and it may not have anything to do with the way that particular company operates. It might just be like a personality clash. Sometimes switching individual managers within your company can be an acceptable change that addresses most of the reasons that you might be considering a switch. So I don't want to beat a dead horse, but I think give your manager the benefit of the doubt. Don't assume that it's going to be a big drama thing when they find out that you're considering switching, and definitely don't violate the meeting statutes out of your fear that might happen. So, Diana, do you want to take us to the next
Sure.
question?
Yes. The next question is, It looks like HOAs can only have open meetings or emergency meetings. Is the board not allowed to get together in any other fashion to discuss priorities, prepare and coordinate our thoughts for scheduled open meetings? And the answer is no. The legislature has decided that transparency in all things is important enough to require it by statute, and that specific meeting statute is, again, RCW 64/94/445. And all of the things that you listed can be done in an open meeting, but the statute specifically prohibits board gatherings by another name. So in any other fashion other than an open board meeting to avoid the open meeting requirement. And again, no, all meetings must be open meetings with very few exceptions. I think that was a short one. Tima, Valerie, do you have anything to add to that?
Yeah.
Yeah.
I mean, the nuance I'll add is this. The statute very, very specifically contemplates, like, if the board members all end up at a barbecue at somebody's house and no association business is discussed, that's not automatically a board member simply because the board members are present. However, if all the board members sort of wink, wink, nudge, nudge end up at a barbecue and oops, accidentally end up talking about a whole bunch of association business that they otherwise would have been discussing in an open meeting, that is specifically prohibited by the statute. So if it is truly a gathering of the board for the purpose of discussing priorities, preparing and coordinating thoughts about certain things that have to do with the community, the whole point of the open meeting statute is that those conversations should be happening in the view of your ownership. So I do think that it's exactly the thing that you asked about, discussing priorities and preparing and coordinating thoughts for scheduled open meetings. Those things are supposed to be happening in the open meetings, especially discussing priorities. So I just wanted to, I guess, emphasize, because I feel pretty strongly about how very clearly the statute is worded.
And I would just clarify, it's a minor clarification, but the way the question was framed, it asks if there can only be open meetings or emergency meetings. I would just clarify that an emergency meeting is an open meeting.
Yes.
That is not an exception to the open meeting requirement. The only exception is for executive session, which is very specific, only addressing specific matters, specifically labor personnel issues, consulting with an attorney to discuss legal issues, contracts or transactions that would disadvantage an association if made in the open, and anything that might prevent public knowledge of a matter that would violate someone's privacy. So an emergency does not qualify under any of those unless one of those happens to be an emergency, which is another exception. So I think that answers the question.
I do want to riff on something else there too. That last one where it's like you can go into executive session to prevent public knowledge of a matter that would violate someone's privacy. Privacy is not defined by how you feel about a subject, okay? Because we have boards that feel that a whole lot of things should be private from the homeowners, but they're not actually things that are legally protected. So when we're talking about something that would violate someone's privacy, we're probably talking about things like, I don't know, if an owner is sharing sensitive personal details, like let's say you've got an owner who's a member of an address protection program because they're a victim of domestic violence. Or let's say you have an owner who's sharing sensitive financial information when they're asking the board for a payment plan. Typically, we say delinquencies should be discussed in open session. But in that particular scenario where there might be sensitive, personal, private information being shared, that might be appropriate for executive session. But you'll notice that none of these things include discussing priorities for governance related to your community, which is really what your question asked about. And so we go back to the answer that no, there isn't a mechanism for boards to meet outside of open board meetings to specifically discuss association business. I think you're up now, Tima.
Yes. So the next question, number 7. When the voting rule says no incumbent or new person running for office should do anything with the ballots, what does that mean exactly? We are a rural HOA. Our secretary picks up the mail and hands it off to the treasurer. The ballots are sealed when they come by mail and are unopened until after the meeting. Does this suffice? So I'd first like to preface the answer to this question by saying it does sound like you're asking for some specific legal advice here that we can't really give in this forum. I don't have a specific reason to believe that simply transporting ballots from the mailbox to the person counting the votes would violate the statute. It's probably fine. But it sounds to me like there's some nuances here that we're not getting the whole picture. And this sounds like something you might want to consult an association attorney about. That being said, keeping in mind that secret ballot requirements only apply to WUCIOA communities right now, we don't have reason to believe that simply transporting ballots is going to violate the statute. But you could switch to a different mailing address for an election if the secretary was running. So if you wanted to have, a separate mailing address for ballots, then you could do that, like a P.O. box, something along those lines. You could consider switching to electronic voting. So, those are some options for you. It's also important to understand and to know that WUCIOA does not define the term secret ballot. We're simply using as attorneys, our experience and knowledge to understand what that means and giving advice based on that. Generally, we would recommend that a committee or a specific manager be left in charge of collecting and tabulating the votes, and that these would not be viewed by candidates until after the tallies have been recorded. And also, the secret ballot requirement only applies to votes to elect and remove board members and to amendments to governing documents. So you're talking about a very specific requirement that only addresses very specific topics. So it's not maybe as big of an issue as you think, although it's hard to know because I don't have all the information that you're asking here for this question. But based on that's the best way we can answer it. Is there anything else you'd wanted to add there, Valerie or Diana?
Nope, I think you covered it. All right, the next topic that we're going to cover very briefly is the 2026 delinquency notice requirements. And the reason that this is coming up is because we had a client share with us that, excuse me, a board member shared that they understood their management company was not sending notices in compliance with the 2026 requirements. And I'd like to preface this whole subject by saying that I do find that a little hard to believe. And part of what I wonder is if there isn't some cross wires in communication between the manager and the board member, because all of the management companies that I work with are bending over backwards to comply with the 2026 delinquency notice requirements. All of that being said, I wanted to just quickly recap what the requirements are. And also I want to cover what happens if you fail to send a notice that complies with the requirement. Because this is gonna happen no matter how hard everybody tries to comply. There are probably some communities that don't even know about these legal changes if they're not WSCAI members, if they're not represented by an attorney, if they're self-managed, etc. So part of the question is, what happens, for example, when an account comes to our office for collection and they haven't sent a notice that complies with the statute? And I guess I'll start there, because what happens is we then kick it back to the client and we say, you have to send a notice. These are the elements that are required in the notice. And you have to void all of the late fees and the interest and the admin fees on this account until after you send that notice and wait 15 days. That's the penalty. The penalty is no late fees, interest, or admin fees, no monetary penalties to the owner until 15 days after you have sent the notice, and B, no ability to move forward with other collection options like a demand letter or a lien or other enforcement on that account until you have sent a notice that complies with the statute. So what the statute says is that when an owner misses their first payment, the association is required to send them a delinquency notice. It has to tell them that the account is delinquent. It has to, tell them how they can make their payment. It has to include a copy of the statutory pre-foreclosure notice of delinquency. This is required to be included now. And it has to be mailed to both the unit and any address offsite that owner has given you. And this includes a scenario where you know for sure the owner doesn't live in the unit. You still have to mail it to the unit anyways. It's required. If you have the owner's email address, you have to send it to them by email, even if they have not opted in to receiving electronic notices. And if you have an owner who then responds to you and says, I can't understand this, English isn't my first language, can you please translate this into, fill in the blank language, Russian, Spanish, whatever. You have to then translate the delinquency notice into their language of choice. Before you send that notice, you are authorized to charge one late fee, which is no more than $50 or 5% of the unpaid assessment that they've just missed, whichever is less. So $50 or 5% of that unpaid assessment. And that's it until 15 days after you have sent the delinquency notice. So let's say in theory, we've got an account that fell behind on January 1st of this year, and it's now May 13th, and a client comes to us with a collection because the owner's 5 months behind now, or almost 5 months behind, depending on the grace period. But they haven't sent any delinquency notices, or they've sent delinquency notices, but none of them comply with the very specific list of requirements that I just gave you. What we are going to do, and what I imagine all the other law firms in our practice area would do, is kick that back to the client and say, you have to send them a notice. Here's the list of all of the elements that are required. And you have to waive all of the late fees and the interest and the admin fees that you've charged on their ledger from January 1 until now, except for one late fee. I think in the first, that first month's late fee of 5% or $50, whichever is less, you could keep that on there, but that's it. And then you have to send this notice, and then you have to wait 15 days. And only after that 15 days has passed can you then resume charging late fees going forward, but you can't retroactively add back what you had to waive because you failed to send the notice in January as you were required by statute to do. So I think that covers everything. I don't want to go too far into the weeds on this particular topic, but I do want everybody to understand not just the requirements of what the notice has to do and say and include, but also what the consequences of not sending that notice are. Now, if you're a community that charges dues annually and you think it's ridiculous to send a delinquency notice, 15 days after the annual assessment was due on January 1, and you typically wait until March, and you don't care about foregoing late fees for January and February, that is a choice that you could make. And you could then send your delinquency notice in March of that year and make sure that it complies with the statute, and just understand that you're taking the hit essentially in your ability to collect or charge late fees, interest, and any other costs of collection until 15 days after the notice is sent. So for a community like that, they might decide that the sending it quickly enough to comply with the statute doesn't make sense for their community based on past practice or whatever, and that's fine as long as you understand what those consequences are. I think I'm going to leave it at that. If there's questions, people can pop them into the chat. And Tima, if you wanted to add anything, since this is your wheelhouse too, feel free.
No, I think that's how we are, that's our interpretation of the statute and how we're applying it at our law firm, and assume how most other law firms are doing. And of course, we don't have a ton of guidance or any case. We have no case law, and we have no statutory guidance at this time. So this is our advice based on best practice and experience.
Yeah. Okay. I think we had one other question from the chat, and then we might end early today unless anybody has. Okay, hold on. There's a follow-up in the chat now. On the collections, understanding that notice is still required for formal collection action, is it okay to be reaching out more casually to get people caught up? Absolutely. Absolutely. We actually covered this last week. So if you haven't had a chance to look at the video for last week, go to the YouTube channel and pull up the video for last week. But with some caveats, including make sure that whoever's reaching out to the owner is absolutely correct on the actual balance due. We think that reaching out to people by phone and email is actually a really great idea. The number of people that don't read their paper mail anymore is astounding to me because I'm old. And by comparison, the number of people that will respond to an email or pick up the phone if you call, is much higher. So I think reaching out is great. But still send the notices that are required by law and your governing documents. All right, there was another separate question in the chat. Oh, isn't there an amount that must be met for the foreclosure notice? Our dues and water fees are low. No, you would think that, right? There is a threshold balance due that has to be met in order to file a foreclosure lawsuit. However, since 2023, it has been legally required to send a copy of the pre-foreclosure notice of delinquency with the first written notice to the owner that their account is delinquent. This is not a new requirement. It's simply that there is now a legal consequence for not doing that, which there hadn't been before. So before this, it was still required that you sent a copy of that NOD with the first delinquency statement or whatever. And then you would send a second NOD no sooner than 60 days later. And then you have to deal with the whole question of does this account meet the threshold balance due in order to file a foreclosure lawsuit? But that's a completely separate question. It doesn't matter how low the balance due is. If somebody is delinquent and you are sending them a notice of their delinquency, the statute requires that you must include a copy of the pre-foreclosure notice of delinquency. All right, next question from the chat. Does the statute regarding budget ratification meeting and process supersede all previous bylaws and statutes? Anybody want to take this one?
Where's the question?
It's way up in the very beginning of the chat.
Oh, okay.
Does the statute regarding budget ratification meeting and process supersede all previous bylaws and statutes? Yes, the answer is yes, it does.
Yeah, the answer is yes, because but this isn't new.
No,
the budget rules have been in place since 18.
Yes.
So there's no change as far as that's concerned. The
Right, but
collection,
I think that what I'm guessing from the question is that this person was unaware that this was the case, and you certainly aren't alone. Even though this particular provision of the statute has been applicable to all communities in Washington state since 2018, we do still, it's less now, but every now and then we still run into a community that is unaware that this is the case. So the statute is RCW 6490-525. And what the statute requires is that the board has to send out notice of the proposed budget to the ownership by mail and include a whole list of specific pieces of information in the budget ratification packet. And then you have to conduct a budget ratification meeting. And at that meeting, unless owners that hold more than 50% of the voting power in the community vote to reject the budget, then it's ratified. So the default is that it's ratified unless it's rejected. You don't have to have a quorum for that meeting to be valid. You don't even call for a vote in that meeting to approve the budget because, again, that's the default, is that it's ratified. But if people at that meeting object to the ratification of the budget, then they can make a motion to reject it. Somebody seconds that motion, and then you ask for people, how many people are voting to reject the budget. And unless the voting power of those votes exceeds 50% of the voting power in the community, then the budget is automatically ratified. So the follow-up question in the chat is it's got to be a public meeting, voting in person, not a vote by mail. Correct. It has to be a meeting of your ownership. It can be in person or it can be virtual. If it's virtual, you have to give people a call-in number to attend by phone if they don't have Zoom, like if they don't have a smartphone or a computer. And you are not doing budget ratification votes by mail. That is not compliant with the statute.
And notice is required under the same rules as the open meeting requirements, 14 days minimum, 50 days maximum in advance of the ratification meeting.
Yeah. All right, there is another question in the chat. I had emailed a question about ACC open meetings that has not been answered. Can you confirm that is it acceptable for ACC to continue to make approvals for roofs, paint our standard colors in the rules, and this can be approved via the software and not in open meetings? I cannot confirm that. Your architectural review committee or control committee, ACC, is bound by the same open meeting requirements that apply to the board, assuming the ACC exercises the authority of the board and makes final decisions on these things. If the ACC is advisory only and is making recommendations to the board, and the board is making the final decisions, then the ACC meetings may not necessarily need to be open. But voting by software and not holding meetings to make final decisions that are exercising the authority of the board would be a violation of the statute, and you should consult with your association attorney about whether this is an acceptable practice for your community to consider. I think that's as specific as we can get on that one here. Okay, Morgan, you give me more credit than I deserve. What is 649505? I don't have the entire statute memorized, so I don't know the topic of that one. You want to put that in the chat? I'll move on to the next question in the chat. Can the ratification meeting be the same meeting where the results of the vote are announced? Yeah, I mean, like by its nature, at the ratification meeting for the budget, you're going to know immediately whether the budget is ratified or whether it's rejected. And also, it's helpful to remind everybody what happens when the budget is rejected. It's not that you're like, oh my God, we have no budget. What do we do? You just revert back to last year's budget. And if the budget is ratified, you need to send out notice to your whole ownership that it's ratified and tell people what their dues are and how, when they're due and how to make their payments and whatever. So you can't just announce it at the ratification meeting and then hope that word gets around within the community. You still need to send out notice to your ownership after the ratification meeting saying, hey, the budget was ratified. Here's your, here's your dues amount for 2026. They're due on the first of each month or the first of each quarter or whatever, you still need to send that notice out to your whole ownership. But you will know the outcome of that meeting one way or the other at the meeting itself. Okay, the question about 649505 was about the rules and what is a reasonable amount of time for comments from the membership. So under WUCIOA, boards can adopt a proposed set of new rules, revisions to the rules, whatever, but then you have to mail them out to the ownership, allow time for the ownership to comment on the proposed rules, and only after that comment period can the board vote to formally adopt those rules and then publish them to the ownership and enforce them against the community. I would suggest that, again, this is not advice, but I would say as a general rule of thumb, a minimum of 30 days. If you're talking about a controversial or really significant shift in your rules that there is a lot of opinions about within your community, maybe allow for more time. And your notice of the rules and the comment period should include a scheduled meeting at which owners can come and actually address the board about the rules before that vote takes place. Anybody else have anything on that one? All right, I think I'm just going to call it because I don't want to be scrambling like I was on that one for any more questions. And it is 10:55 anyway. So thank you all for joining us. We were happy to have you here with us today. We'll see you next week and then not the following week. Have a great week, everybody. Bye.
Thank you. Bye.